Number 5, Artibee versus Home Place Corporation. Counsel?
May it please the court. I'm Rob Coughlin. I'm of counsel to law firm of Town, Ryan and Partners in Albany, New York, and I'm here on behalf of the plaintiff appellants, Carol and James Artibee. I'd like to reserve 3 minutes for rebuttal, please.
You may have 3 minutes, sir.
Thank you, Your Honor. The issue is whether CPLR 1601 should be interpreted to allow a claimant in Supreme Court to submit proof against the liability of the state who could not otherwise be sued in Supreme Court.
So what's the impact, counsel, of the judgment in Supreme Court on Court of Claims?
Zero. There is no res judicata
Just de novo
effect.
consideration.
Correct. The Court of Claims will have to decide it on its own merits. However, that is not to say that there isn't some significant impact upon the state that should be avoided by virtue of this statute. In fact, the statute does address the situation where the state is sued in the Court of Claims and allows apportionment of a non-party tortfeasor under those circumstances to allow the state to reduce its liability to perhaps below 50%, so that would only have to pay its equitable share.
How would that work, counsel, if the Artibees have to sue Home Place, the defendant, in Supreme Court, and if Supreme Court, and then sue the state in the Court of Claims, if in Supreme Court Home Place is found not liable, then there is no apportionment in the Court of Claims, right?
I believe that the state would still have the right, because it was not bound by the determination in Supreme Court, to allege that Home Place was indeed liable under these circumstances, which is obviously going to result in a potentially inconsistent verdict. But unfortunately, that's the nature of these parallel court systems.
But your client could get complete relief, or your clients could get complete relief in the Court of Claims then?
No, because if the state were successful in establishing significant liability against the Home Place Corporation, in fact, 100%, because that case will go undefended by Home Place Corporation, then the plaintiffs could theoretically end up with zero in both circumstances, because they're faced with a situation where either in Supreme Court, if there's an empty chair, or in the Court of Claims there's an empty chair, the defendant in either of those cases could try to slough off complete liability onto the empty chair, rendering the verdict zero in both instances.
Let me ask you this. What would the verdict sheet look like under the trial court's decision? Just by way of background, the way I read it, it seems to be what the trial court is saying is that there's going to be the normal negligence question is, number one, was Home Place negligent, and number two, was Home Place negligent approximate cause of the accident, and that the evidence against the state, if there's no apportionment against the state, will go to the proximate cause issue. Is that your understanding? And the other attorneys, I'll ask to comment on it when you come up too. Is that your understanding of the way the verdict sheet would look?
I suppose that would be the way it would look, but then there would be...
I'm not talking about the instruction, just the verdict
Correct.
sheet. Right.
Correct.
The instruction itself may be something different, and no one isn't exactly sure what that would be because it came up before there was instruction on it, right?
Correct, and I wasn't part of that, and I'm not sure what it would ultimately look like, but
Right.
Ultimately it would be confusing to the jury for sure, because...
Well, either way, these cases are always confusing to the jury, one way or the other. So that goes without saying. These are not, they aren't simple to litigate. I understand that. But usually the procedure is that you litigate in Supreme Court first, and then whatever verdict you get, you go to Court of Claims, and you litigate that separately.
Correct.
So you could conceivably result in both parties being over the 50% in 6101.
Correct.
Can we assume from your answer that the trial has not taken place?
That is correct. It's been on hold for a while now, pending the result of this particular issue. So that, I think, unless the court disagrees, I think we can all agree, let me know if you need me to explain it, that in the Court of Claims, they have the right, the state has the right to apportion liability against a non-party defendant. So the statute specifically addresses that situation. What it doesn't address, apparently, and either the statute does address the converse situation or it doesn't. Let's assume for the purposes of this portion of my argument that Judge Rose was correct in the Rizuka case and Professors Alexander and Siegel were correct, that the statute is silent. Let's assume that for the time being. That silence is resounding because, in fact, the legislature, in passing 1601, recognized the problems associated with the parallel court system, and it specifically addressed the situation where the non-party tortfeasor could be apportioned liability in the Court of Claims. It did not, however, address that in the situation where the converse situation, where the state is a non-party in the Supreme Court action. That silence is significant because this court has stated in the Wrangelin case, which also addressed Article 16, that the statutory canon of construction, exclusio unius est exclusio ulterius, I've always wanted to say something Latin in court, says the inclusion of one is the exclusion of the other.
Counsel, I'm sorry to interrupt you, but
Yes.
before your time runs out, one of the arguments, as I understand the defendant is making, is if your interpretation of the statute's jurisdictional requirement is correct, why do you need the workers' compensation carve-out?
I'm sorry, Your Honor?
Why do you need the workers' compensation carve-out in 1601? Why would they have passed that in 96?
Well, in
You
96,
wouldn't have
there was
subject matter
a
jurisdiction.
massive tort reform associated with workers' comp to get around Dole versus Dow. There was apparently a pushback that employers were being sued. They're doing an end around. And so to address that, a number of statutes were changed to allow what the legislature determined should be the sole exclusive remedy.
I understand
Yeah.
that, and I understand the statute, but why would you need it in this statute? I understand 16024, but why would you need it here where, if your interpretation is correct, you wouldn't have been able to go against the employer anyway because of the lack of subject matter jurisdiction?
Well, they addressed in this situation to assure that the exclusive provisions of workers' comp were allowed, except for the situation of grave injury. They had to synchronize those statutes to
Right,
allow.
what this 1601 says to me, and I'm sorry, I know your time is out, if I might just follow
Yes.
through on this. 1601 says to me is, if it isn't a grave injury under the workers' comp law, then forget that party for equitable, for impleading, for the share, if your interpretation is correct, why would you need that provision in 1601?
I'm not sure I understand the question. Have to.
It just, we leave it and maybe someone else will answer, but it seems to me that it's a carve-out that would be unnecessary because it would already be prohibited by the plain language of the statute under your reading.
It's not a question of personal jurisdiction, though, in regard to a claim against an employer.
It's subject matter jurisdiction.
No, it's exclusive remedy carved out by the statute that says it's just a bar to allow an employer to only have to pay once of their workers' compensation. It's not, I don't look at it
Why
as.
isn't sovereign immunity just a bar?
Well, sovereign immunity would be a bar, but for the Constitution and the Court of Claims Act. Certainly, the legislature in this particular case had every right to treat the state differently from the defendants, although the defendant takes the position here that the state should not be treated differently. There are ample reasons that the legislature may have wanted to have treated the state differently. Sovereign immunity being one, perhaps allowing the state to the legislature may have determined that the state should not be subject to a jury determining the negligence of a state when it's constitutionally mandated that its negligence should only be considered in the Court of Claims. So there are significant differences between the state and other defendants to justify the distinction made that we're propounding was recognized by the legislature in passing Article 16.
Thank you, Mr. Coughlin.
Thank you.
Counsel?
May it please the court, Frederick Brody for the state as amicus. Section 1601 is not silent on this question. Its plain language requires reversal. By authorizing apportionment in some circumstances, Section 1601 creates an incentive on plaintiffs to sue all the potential defendants and rope everyone in. In line with that logic, apportionment.
Well, how is this disincentivized if we follow the third department, if we agree with the third department's view?
I'm saying, how does,
There's a disincentive to that. You've got to sue, you can only sue the state in court of claims, right?
right,
Right? There's everyone else you've got to try and sue in Supreme Court.
right,
And either you have jurisdiction over them or you don't, personal jurisdiction.
right. And if you don't have jurisdiction,
Personal
personal or
jurisdiction.
subject matter jurisdiction, I think the
But
statute.
how are you not going to have subject matter jurisdiction in a personal injury action in Supreme Court?
Well, you don't have subject matter jurisdiction over claims against the state.
Well, I understand the state. No, I'm asking about everybody else.
Everybody else can apportion among themselves in Supreme Court. I'm here for the state.
I understand. Let me try it a different way. Is your position that the language in 1601, that reference to jurisdiction, is jurisdiction to personal or subject matter or both?
Both. It can be reasonably read and should be read.
All right,
to
so what I'm asking then is, how is subject matter jurisdiction applicable to everybody else, not the state? If it's a personal injury action, right? What would be the ground that you wouldn't have subject matter jurisdiction?
I suppose if there were a federal defendant, you wouldn't have subject matter jurisdiction over them either.
Mr. Brody, what's the harm in apportionment in the Supreme Court?
Well, it distorts the apportionment process in three ways. First is the empty chair issue, that because the state can't defend itself in Supreme Court, the defendant would receive a windfall because the jury will likely inflate the percentage of fault attributable to the state.
But how
Second
does that
is-
But
affect
it's
you?
not binding, right?
It's not binding in the Court of Claims. How would that affect the state in any meaningful way?
Well, that follows from the second issue, which is the whipsaw issue, because when the plaintiff then turns to sue the state in the Court of Claims, the state mounts a full defense, and the plaintiff winds up bearing the loss occasioned by Supreme Court's overestimate of the state's fault in the original action. Now, the Court of Claims judge might be sensitive to that whipsaw, and they might try to avoid whipsawing the plaintiff by acting consistently with Supreme Court's jury verdict. But if they do that, then the state will again have its fault overestimated. So you've got those three distortions. Now, the state's reading of...
How does the Court of Claims judge find out about the verdict in Supreme Court? Is that because the state would bring it up?
Well, I'm sure the judge,
Would?
well, for one thing, when these cases go through discovery, they should ideally be coordinated. You shouldn't be taking two sets of depositions of the same people and having potentially conflicting motion practice and conflicting trial dates, so
What
it
if the
makes
Court
sense.
of Claims goes first?
If the Court of Claims
Then
goes...
it doesn't affect any of the things you just said, right?
That's right. In this situation, it appears that Supreme Court's going first.
That isn't usually the situation, though, is it? Usually, I was a Court of Claims clerk for a while, about 30 years ago, long time ago. But at that time, it seemed like there were times, so states, if you had multiple defendants, the state Supreme Court verdict would come in first, and then the Court of Claims judge could then react to it. Can I just follow up on the one question I asked the other party is, what would the verdict sheet look like in the trial court judge's decision here? You heard that question.
Well, under the state's interpretation, the verdict sheet would just say, is the defendant liable or is the defendant not liable? And what happens then?
Well, no, slow down. First he'd say, is he negligent? And then is there
Right.
approximate cause?
Right,
Those are the
the
questions
elements
he'd ask.
met, and is the defendant liable? But there's no apportionment. And so what happens then to the
Slow
defendant?
down. So, yes, so that's what the plaintiffs also agree with you. That's what the verdict sheet then would look like. You're both saying that that's what the verdict sheet should look like under the trial court's jurisdiction. So do you object to the trial court saying proof of your negligence can come in even in the absence of your presence, but there's no apportionment. Are you objecting to that decision? Or are you just objecting to the apportionment requirement that the AD set up?
We're just objecting to the apportionment. I think the court can give a curative instruction saying,
In other words, you can put in proof of somebody who's not there, that's fine, just like you could in
Right.
any other case, but
but the
there's
court
no
gives a
apportionment.
curative instruction and says, look, don't consider this as to the state.
So in this case, nobody objected to having the proof of the state's negligence be part of the case.
I think the plaintiff did object to that, but that issue hasn't been raised in this appeal.
And was it raised in the appellate division?
It was raised in the appellate division, and the appellate division didn't reach it because they didn't need to. They said, well, you're going to have apportionment. So the evidentiary issue became moot.
I have a letter in the file, in the record, I should say, of September 30th, 2014, in which the plaintiff writes, it's plaintiff's position that nothing bars the Supreme Court jury from hearing evidence at trial as to the state of New York's potential liability for Mrs. Artibee's injuries. Did that position change at some point before the trial court?
I think the briefing in the appellate division, the plaintiff took the position that there shouldn't be evidence introduced.
But to your knowledge, that position was not taken in the trial court?
I don't know, Your Honor. You would have to ask plaintiff's counsel for what their definitive position is. If I may conclude.
Assuming that is the plaintiff's position, that it would be fine to have evidence of the state's liability before the jury, but no apportionment, I am having a little difficulty understanding what the jury is supposed to do with that.
Well, you would need a curative instruction saying, you, the jurors, are only supposed to decide the liability of the defendant before you, and you're not supposed to decide the liability of the state. Now, specific evidentiary questions are really best considered in the context of a concrete offer and a specific objection. We don't have that here, so we're all talking hypothetically, but the state's position is that you could have a curative instruction that when some evidence comes in that suggests the state's liable, you can say, look, you, the jury, are only supposed to be deciding the liability of the defendant here.
But in the absence of an apportionment question in the verdict sheet, I'm assuming that the charge would be that the evidence was really only going into the proximate cause question.
Well, that's right. You know,
Right.
if the state did something that means the defendant is not liable.
Right.
Mr. Brody, you had another point you wanted to make?
I did. Thank you, Your Honor. I've explained the three distortions that are caused by the defendant's reading of the statute. And I just wanted to explain why the state's reading of the statute yields the most accurate allocation of fault. It's the most accurate because what happens is the defendant, in the first instance, winds up liable for 100% of the damage in Supreme Court. But then the defendant has the right to go to the Court of Claims and sue the state for contribution. In that action, both of the alleged tortfeasors are before the court. Both the state and the defendant are incentivized to and are allowed to make a full case on the allocation of fault. So finally, you have a court with both defendants, both tortfeasors before it, that can allocate fault among them based on a full record. And then ultimately, the defendant will be able to recover its the correct proportional amount from the state, because the state, of course, is able to pay a judgment.
Thank you, sir. Counsel?
May it please the court, my name's Tom Johnson. I'm the attorney for Home Place Corporation.
What's wrong with the state's analysis? I mean, it seems to me that no matter which way we look at this,
Right.
there's going to be an empty chair
Of course.
in some situations.
There's nothing that this court or anyone can do unless the Constitution's changed.
So why isn't the state's analysis the fairest way to go about this?
Well, because there is an assumption that the that there will be a verdict for the plaintiff, and then why should the defendant be the one who has to go and pursue the state? I think that the better.
Well, no, I don't think there's a presumption that there'll be a plaintiff's verdict. It's just that in the case in which there is a plaintiff's verdict,
Right.
it reaches the best result.
Well, I don't think that it is fair to the defendant. I think that the plaintiff is the one that has chosen and has actually, in most cases, sued both parties, both the non-state entity and the state and the Court of Claims, which of course is the situation
But in your
here.
scenario, the defendant then gets this opportunity to, to argue against the empty chair, which, even though it's not collateral estoppel or res judicata, there's a risk that the Court of Claims would take that into account.
Well, I don't like to think that the Court of Claims would necessarily abdicate its responsibility there. I think that,
Well, I'm not
they-
suggesting that the
Right,
Court of Claims
right.
would do that. What I think we all know that there's, that there's always a range. There's no exact right answer, and, and even Court of Claims judges are human.
Of course, yes. Well, it is a possibility, but I don't think that the statute requires that possibility. I think that the statute's language, in doing the statutory analysis, is you would look at the statute first, and I think that it's very clear that the word jurisdiction used in the first proviso
Well, it doesn't say personal jurisdiction.
Doesn't.
Wouldn't that make it perfectly clear?
It would make it perfectly
Okay.
clear, so that's why we have to be here, of
That's
course,
why
is
we're here,
because it
exactly.
isn't perfectly clear. But what the devices that we have that are available to you to interpret this word are that that's the interpretation that has been placed on the word by the other lower courts, which of course are not binding on you.
Well, I find that a little curious, because it seems to me that all stems from Professor Siegel, that everybody reverts back to Professor Siegel, who, when I read his commentaries, just sort of makes that assumption on his part, and curiously, even more curiously, Professor Connors disagrees with that, apparently. So I'm not sure where that leaves us.
Well, it wouldn't, except for the fact that the passage of time, and as Judge Garcia noted, and which I, of course, noted, is that we did revisit the statute when we added the second proviso involving the workers' compensation bar, which would be completely unnecessary if the word jurisdiction applied to both. And so we, cannot, of course,
So
assume.
it's your view, counsel, that the inability to bring in an employer would be subject matter jurisdiction?
Yes, that is my interpretation. And so that argument that the second proviso means nothing, I think slights the legislature. The legislature added the parenthetical that we talk about, which was to expand, give apportionment to, available to the state in a situation where it's very clear there would be no personal jurisdiction over anyone. And so that's crystal clear that the only party in a court of claims case could be the state. And so they added the parenthetical, as is said in the legislative history, to be sure that they got the same rights as everybody else. And I think that the legislative history indicates that the legislature was not intending at all to have that parenthetical revert back to further limit the rights that it was clearly giving in the general provision.
But
which is-
doesn't the legislative history also indicate that it was concerned about, there was a crisis of insurance and low liability, deep pocket
yes.
defendants? But that does that apply when the state is the other tortfeasor?
Well, let me answer the question in this way, Judge. First of all, the one entity that is going to always be available in one place is the state. The problem, of course, for non-state entities which are not parties to the Supreme Court action, would be that there may not ever be a forum where the plaintiff could recover this amount of money. But the plaintiff always can get jurisdiction over the state. It's always subject to personal jurisdiction in the state, not in the Supreme Court, of course, but in the Court of Claims. So the damage
So
of
why
a
isn't the
portion-
language unable to obtain jurisdiction over such person? Why have the rest of the language?
in said action? Well, I think
What's
that.
the rest of it? What does that further? Let me put it that way.
I think that furthers the situations where there can be, the tortious act, it occurred outside of the state, which has consequences in this state, that may give personal jurisdiction in some circumstances to an out-of-state defendant. So I think that the in said action does not have the import that the Attorney General suggests, which means that it's got to be subject
Well,
jurisdiction.
staying on your jurisdictional argument, if, the way I understand the argument is that the position of the plaintiff doesn't change. The plaintiff still cannot get jurisdiction in state Supreme Court, but this decision at the appellate division would allow the defendant to get jurisdiction in essence over the state in state Supreme Court for apportionment purposes, but no one else. Is that correct? Am I reading that correctly?
Well, the defendant, of course.
Because it's an odd situation that the plaintiff wouldn't be able to, but you can get, as a defendant, can get.
The defendant, if it feels that it's been wronged by the state, can always sue the state in the Court of Claims. So I don't think that the appellate division decision is granting the defendant any more rights than it already had.
You don't think it's giving the defendant a right that the plaintiff clearly does not have?
The right to.
Apportionment against the state that the plaintiff couldn't claim itself. You see the anomaly here. One party is being, in essence, granted a right that another party clearly does not have by either Constitution or by statute.
Well, I have to say, Judge, that I did not consider that. I did not.
I
think
didn't
that-
either till this afternoon. I want you to know this is, the light went on about this
Okay.
afternoon. But it seemed a very strange anomaly. And I think we all recognize that this is a difficult, convoluted area of the law. But it seems pretty clear that that would be the case if we follow the AD.
But is that in line with the purpose of the statute?
I don't believe it is. The statute, of course, was designed to give relief to defendants. That's what it was designed to do.
But that's what I'm saying. Doesn't this further this if the plaintiff is perhaps not on equal footing with the defendant in this way? Because you're seeking to protect the low-fault, deep-pocket defendant.
That's right. I think so. Could I answer your question that you had about the verdict sheet?
Yeah.
I'm going to disagree with you, Judge, that I don't think it goes to the proximate cause issue. I think it goes to the negligence issue. Because having been in that situation where you're presenting all of the facts concerning the event, and you're pointing to that there are other people who had other duties and actions and responsibilities, then the argument that would be made at the summation would be, my client was not negligent because it did not violate any duty, it did not have notice.
That's a good argument. You might be right. We're never going to know because we haven't seen how it's
don't.
played out, but that's certainly a legitimate point of view.
It's
But I've always found that the proof really applies against both questions, question A,
course it
negligence,
does.
and B, proximate cause.
It does, but I think that when we see how Judge Krogman in his hypothetical in the decision at page 7 in the record, and how it played out in the Cabrera case, which was tried in Westchester Supreme Court, referred to by the Attorney General, is that what happens is that there becomes not an apportionment at all, but simply a defense verdict. And so that's not, so all that parade of horribles doesn't really affect the question of apportionment. Thank you very much.
Thank you, Counsel. Counsel?
Judge Fahey, I appreciate you're looking at this from a practical standpoint. And I want to talk about some of the practicalities of a lawsuit brought by a plaintiff in a Supreme Court action where the state's liability or negligence can be determined. And one of the reasons that it should not be allowed, and maybe the legislature did in fact make a distinction. from a practical standpoint, the plaintiff proves his case against the defendant submits uncontradicted proof against the empty chair. Not only does that skew the verdict, but it also could leave the jury with the impression, and we're talking practical here, that the state's totally incompetent. The state was not there to defend its position, and therefore the state's liability or negligence will be skewed. Jury will go away saying, well, it's the state's...
Is that your position? Judge Stein asked earlier, counsel, did the plaintiffs change their position from when they were before Supreme Court and then they got into the appellate division? Because as I read the Supreme Court decision, it seemed that plaintiffs were consenting to evidence against the state coming into the Supreme Court trial, but were against apportioning liability.
I think the record does show that that was the case at the Supreme Court level.
So did you change your position when you got to the appellate division?
When I was, yes. That was when I was not involved with that Supreme Court level. I came into the firm, I looked at it and said, you know what, I don't, so yes. I made a different argument at the appellate division level.
Counsel, if we adopt your rule, would it affect apportionment in these issues for bankruptcy issues or for settling tortfeasors?
No, Your Honor. The settling tortfeasor situation under General Obligations Law 15108 was specifically addressed by the legislature, and I think that's a separate entity. That system's been set up and
How
ready
about
to go.
bankruptcy?
Bankruptcy, I do believe, is an issue that has not been decided by this court.
But would we be deciding it here?
You probably could forge a decision that did not have that impact. I haven't thought that all the way through, but to the extent that the state courts, as opposed to the federal courts, who decided that it's not effective jurisdiction, but the state court has found that the Supreme Court can in fact exercise jurisdiction over a debtor, and that the automatic stay is not a jurisdictional issue. But one last point, though, is that the goal that the proposition that the plaintiffs are proposing here could in fact be readily accomplished by the deletion of 10 small words in the first proviso. If we struck out "in said action" and the language after that, we can establish the goal that the defendants are proposing would be achieved. Two things. One, if the liability of a non-party defendant shall not be considered if they cannot obtain a jurisdiction. If that language was stricken from the statute, then the plaintiff could always obtain jurisdiction. The plaintiff can always obtain jurisdiction over the state, and therefore the goal that they're trying to achieve would be established by the omission of those small 10 words. The inclusion of those words makes a significant difference and lends support to our proposition that the state's liability should not be apportioned in Supreme Court.
Thank you, counsel.